Good evening, everyone. Welcome to this webinar on how to maximise and defend high value claims in the Employment Tribunal. It's a rather broad and perhaps a slightly ambitious topic title because of course, we all know that the issues that are thrown up in terms of remedies in any tribunal claim are many and varied, and it isn't possible, obviously, to cover every possible scenario. But hopefully Ben and I are going to get you thinking about some practical tips and some ideas for exploration if you're having to deal with a potentially high volume claim, whether that's on behalf of a claimant or a respondent, and the types of evidence that you might need to be able to get the best possible outcome for your clients. If you have a question you'd like to ask Ben or I that occurs to you during the course of the webinar, please do pop it in the chat box during the webinar, and we'll endeavour to leave enough time at the end to answer as many of those questions as possible. Now, the tribunal statistics, which show us the level of awards in tribunals, aren't really a reliable barometer for the value of all claims being litigated in the tribunal system, because, of course, we all know that many of those claims are settled either before they reach trial or certainly before they reach a remedies hearing. And the latest statistics we have for the year 1920 have some surprisingly low maximum awards, actually, for most types of discrimination claims. Apart from age and disability, who both had maximum awards in the region of about $250,000. But so far this year, we know there's already been one award by the Croydon Employment Tribunal of just over $2.5 million in a discrimination claim, in a disability discrimination claim. So although those claims are the exception rather than the norm, we know that the stakes are potentially high for your clients. In the webinar, Ben's going to be talking to you about what I refer to as the non-financial loss elements, if that's the right description. But by that, I mean injury to feelings awards and the likes. And I'm going to be talking to you about the financial losses, so including briefly touching on the dreaded pension loss. And I have focused mainly on discrimination claims because they are probably the most common claims likely to lead to high value awards. But of course, many of the principles apply equally to all types of claims, with the caveat, of course, that some other claims will of course be subject to statutory caps. So looking at financial loss, schedules of loss. So starting with the very basics, it might seem trite to say that schedules of loss are important, but I thought it was worth emphasising that you shouldn't underestimate the value of preparing either a comprehensive schedule or for a respondent to counter schedule, and to do that at an early stage of the proceedings. So tribunals routinely do now order them anyway, but in terms of your case preparation and strategy, it is an important element. And all too often, I think parties don't engage with the issues of remedy until much later down the line, when it's often too late for that to dictate the strategy you might take. So you want to have in mind the value of your claim and how you're going to maximise or defend it so far as the remedies are concerned at an early stage, because that's going to dictate your case preparation. Everyone differs in terms of their style of schedule, but essentially you want to be thinking, how easy is this going to be to understand for a judge and wing members who are looking at this for the very first time at trial or at a remedies hearing? They don't want to see reams of mathematical calculations or complicated spreadsheets. They want to see something that's easily digestible and is simple to navigate. If you need the spreadsheets, by all means, prepare them, but keep them separate to your schedule. I'm a big fan of having a schedule that sets out the basic figures for calculation in sort of a header at the top of the schedule. And often they should be the figures that are capable of agreement with the other side. So your tribunal has an easy reference source for things like the amount of gross and net weekly pay, pension contributions and things of that nature. And then once you've dealt with those basics, then go on to set out your case on the various different heads of loss. be as specific as you can in each section of the schedule, even at an early stage of proceedings, even if that means you have to err slightly on the side of caution, because nobody can then accuse you of having taken them by surprise at a later date on a particular issue. And try to avoid putting in the dreaded to be confirmed, because what that really shows is that you just haven't yet engaged with that particular issue. So, for example, for claimants, be clear at an early stage, for example, what you think the appropriate injury to feelings award might be, even if you just provide a range. For respondents, try to think about all of your remedy arguments, so not just the failure to mitigate or engaging with the mathematical calculations, but also including your arguments about adjustments like Polke deductions, because again, that dictates your evidence and the strategy that you're going to take. So really, you need detail, but to be digestible. It's not your remedy submissions, it's just a skeleton of the figures involved. And it's likely, of course, that the first and potentially most significant head of damage you're going to include in your schedule is your loss of earnings claim. That can often account for a very substantial part of the award in a high value claim. And that's, of course, increasingly the case when the economy is unstable and there's a difficult job market. The general principle, of course, in assessing compensation is that as far as possible, claimants should be put in the same position that they would have been in, but for the unlawful act. So when you're looking at past loss, that's generally relatively simple because it's a known quantity. Although, of course, sometimes you might need to look at what might have happened by the time you got to trial. So what would have happened but for the discrimination occurring. For example, for a respondent, you might want to contend that a dismissal would have happened anyway, despite the discrimination. For the claimant, you might want to be saying, well, by this point in time, there would have been promotions that would have occurred shortly after dismissal and in the period before trial, or other events that are going to increase your loss. And you also need to bear in mind any arguments over, of course, whether the loss actually flows from the discrimination and whether that's going to be said against you that it doesn't flow from the discrimination. But essentially, the past loss should be a relatively simple calculation because it usually involves limited speculation. Where things get more complicated, of course, is the future loss of earnings, because the tribunal is having to use its judgment to try and predict how long the claimant's losses are going to continue. So if the claimant is still unemployed at the date of trial, as claimants obviously in high value claims often are, that might mean considering a significant number of issues like the job market and factors relating to the individual themselves, such as their age and skills, and of course their health. I've set out there in bullet point form what the EAT said in the Atos Origin and Haddock case. The EAT summarised the main principles governing the assessment of future loss. So I'm not going to go through those, but it's worth just having a look at that to understand the basic principles. So this is probably one of the most difficult exercises for a tribunal in a discrimination claim to do, and it often becomes complex when claimants are, for example, claiming loss of promotion opportunities over a long period of time. So what you will often have to do is take an incremental approach to that loss and to break down the loss into chunks of time to show what would have been the career progression throughout the relevant period. So looking at the sorts of evidence that you might want to be considering, for respondents, on behalf of a respondent, you want to, when you identify that a potentially significant loss of earnings claim might feature, it's worth, again, at an early stage of proceedings, identifying that with your client and asking them to do some homework in relation to alternative employment positions, whether that be with them or whether that be in the job market in general, and to keep any documents that show available positions to assist with your assertion later down the line that the claimant hasn't made sufficient efforts to mitigate. So often clients make the mistake of doing this, but not until just before a remedy hearing, when the claimant might already by that stage, particularly in the current state we're in terms of cases being listed so far ahead, the claimant might already have been out of work for at least a couple of years. And the evidence therefore isn't properly assisting the tribunal in understanding what the job market was like at the time their employment came to an end, as well as looking into the future. So remember that the burden of proving a failure to mitigate is on the respondent, so you need to adduce sufficient evidence to satisfy that burden. I would say please don't ask a trainee to churn out hundreds of pages of job adverts from the many job websites there are nowadays, which is something that we see quite commonly. What happens is you then end up with a gigantic remedy bundle full of job adverts. They are always, in my experience, of very limited merit, not least because if the other side then goes through them in detail, they'll undoubtedly pick apart why the vast majority of those job opportunities weren't suited to this particular claimant and actually might be counterproductive. Yet by all means do those job searches, but try and make them as focused as you possibly can with the knowledge that you have about that particular claimant. And in addition to doing those job searches, which show the general state of the job market, often your own clients will be able to provide evidence, for example, of their knowledge of that particular sector. That's something that's frequently overlooked. So a witness statement from a relatively senior employee who has some general knowledge about their sector, about the job market in that sector and recruitment in the claimant's chosen field will be better than nothing when it comes to assessing the likely future prospects for the claimant. You can engage a specialist employment consultant to advise on these issues and to advise on the job market generally. But beware that if that's a joint report, if you're acting for a respondent, if it's done with a view to the consultant meeting the claimants themselves rather than just advising generically, that can backfire for a respondent if you get an unduly negative report. So often it's better to take some of the alternative routes of having more general evidence from a respondent's perspective. If you do decide that that there's merit in going down the route of a consultant's report, or you think it's appropriate there should be a joint report if the claimant is keen on one, one thing you can do is combine that with an offer to the claimant for them to avail themselves of the consultant services at the respondent's cost. So often the individuals who will advise on these things are also in the business, for example, of assisting individuals trying to find work, whether it be by way of providing advice on preparing CVs and job applications, or providing advice about a change of career, things like that. You can offer that. Now, while most claimants won't take you up on that offer, you can point to that as potential evidence that you've been attempting to assist the claimant in mitigating their loss. And of course, if they reject it, you can point to it as a lack of mitigation. It makes your clients look more reasonable and like they're doing everything they can to assist the claimant. And it might also flush out whether your claimant is not being entirely upfront about quite how zealous they are being about searching for alternative employment. Similarly, on behalf of a respondent, the other thing that's important to do in terms of evidence is to collate any available evidence about their own position in the market that's relevant to this issue. So evidence of uncertainty ahead in respect of their own business, which might, for example, support a finding that the claimant would be at risk of being fairly dismissed, for example, by reason of redundancy in the future. That's a tricky one to handle because, of course, often respondent clients are not terribly keen to declare that their business is struggling in any way. So it has to be dealt with sensitively, but it can be important evidence if there really is clear evidence, for example, that they're having to make redundancies and that the claimant's career with them would have been short-lived in any event but for the discrimination. So evidence for claimants, probably the first one to note is medical evidence. If you've got a situation where the claimant hasn't yet been able to start searching or is saying that their medical condition impacts upon their search for employment, you're going to want to adduce clear medical evidence about that and why they've not been able to mitigate their loss so far and the impact it's likely to have on them in the future. You're going to want some evidence from them, obviously, about their job searches so far. That's even the case if they haven't been well enough to get back out there on the job market. It's wise, for example, to have some evidence of their understanding of the market from their perspective and their understanding of their own sector, which they should be able to comment on. So even if they haven't actively been making applications, you should be saying to your claimants, you know, you do need to be very much observing the position of the job market and what is happening out there in order to be able to give some evidence about that. And again, from a claimant's perspective, there is probably more merit if you're thinking of a high value claim to consider an employment consultant if you think, for example, there's a potential for career long loss, if it's likely that your claimant is either unlikely to be able to work again at all, or more likely if they're going to be unable to work in their chosen field or get back on that career ladder at the same level as before. A focused consultant's report where they've met the claimant rather than a generic report is likely to be persuasive. And that then brings me on to the question of stigma in relation to future loss. The Court of Appeal case in Chagga and Abbey National looked closely at the way to assess future loss following a discriminatory dismissal of what was a highly paid city worker during a redundancy round. And one of the issues the Court of Appeal considered was the question of how individuals should be compensated where stigma affects their ability to find alternative work. And the court held that the fact that third-party potential employers, so the people that they're going to try and seek new roles, that if they themselves are acting unlawfully by declining to employ someone because they previously brought tribunal proceedings, that doesn't prevent the original employer from being liable for losses arising, which is what Abbey National had argued. So in cases where an individual, for example, would have been dismissed even without the discrimination occurring, and where the claimant is saying, well, my future loss claim is therefore based even solely on stigma. So yes, I would have been dismissed in any event, but because of the circumstances of my dismissal, I'm now unable to get another job. The burden of proof of showing it is stigma and not any other reason hampering mitigation will fall to the claimant. So it doesn't need to be dealt with as a separate head of loss. On the contrary, it's a factor for the tribunal to consider in determining the future period during which the claimant will suffer loss of earnings. But Lord Justice Elias said that it would be wrong for a tribunal to infer that an employee will suffer widespread stigma purely on the basis of an assertion that might, or a mere suspicion that might be so. You do need some evidence about it. In the Chagga case, that was extensive evidence about very many applications for jobs that were unsuccessful. It's going to be obviously potentially your most common evidence. But you will need some evidence. That's going to be more difficult where you have a claimant who hasn't put themselves on the job market for health reasons prior to trial. Then you might want to turn to some expert evidence on that issue if you think that this is a real concern. For example, you might want to think about a report from a recruitment consultant, someone in the claimant's chosen field, to talk about the types of things that are generally factored into recruitment decisions and to comment on the likelihood that the circumstances of the previous dismissal or the fact of bringing proceedings is likely to impact on recruitment in what may be a competitive market. Of course, nobody is going to say, well, we won't recruit people in those circumstances, because of course that would actively amount to victimisation, but some evidence of the commercial realities from an independent individual as to the impact is going to be helpful in that regard. And I've mentioned there the Small and Shrewsbury and Telford Hospitals case, because that's a case where the EAT held that the tribunal isn't required to consider whether to award stigma damages where the claimant hasn't argued in favour of that award, and you can't raise it, for example, for the first time on appeal. So you do need to be dealing with the issue head on. It's one of the things that you need to be thinking about at an early stage. And one thing to bear in mind on the question of stigma, which is a relatively new issue for claimants, is that automated online reputation screening is now playing an increasing role in recruitment processes. So this is to the rather scary tech world of sweeping the internet for information about job applications, whether that be their social media profile or otherwise. And of course, we now have judgments published online. There's a very interesting article written by Zoe Adams and Abby and Jeremias Adams Prassel on this issue about the impact of online, of publishing judgments online, where, amongst other things, they observe that it's not difficult to envisage how an unscrupulous provider of these kinds of screening services might essentially rely on the tribunal's database to de facto blacklist applicants who brought claims in the past. It's a really fascinating paper. I'd commend it to you, even if you're not having to think about a stigma damages claim. There's some interesting information in there on that basis, but just from a general interest and perspective. And I've included the link there in the PowerPoint slide. The other point to note from the Chagger case is that the Court of Appeal agreed that future losses had to be discounted to reflect the possibility that had there been no discrimination, there would have been a dismissal anyway during, for example, in that case, the redundancy procedure. So that case made it clear that in compensation along Polke lines might serve to reduce future loss, potentially all the way down to zero. The circumstances justifying that are likely to be rare, but if you're acting for a claimant, you need to be prepared to respond to any assertions that there would have been a lawful dismissal absent any discrimination. Similarly, if you're acting for a respondent, you're going to have to think about the evidence you adduce about that. You can't make bare assertions about a potential dismissal. That brings me on to the dreaded pension loss, and I'll skip through this so that we can move on to Ben's part of the talk, and we'd leave enough time for questions. You'd be pleased to hear I don't intend to provide a comprehensive analysis of pension loss. That's a webinar all of its own, but of course this is one of the most significant losses employees can sustain as a result of a discriminatory dismissal, particularly where there's a final salary scheme. Contrary to what people think, pensions don't actually enjoy special status in the calculation of loss. They're essentially part of the remuneration package. I've referred there to the Ejon Corporate Services and Roberts case, where the EAT held the tribunal in that case had been wrong to class a final salary pension as an unquantifiable benefit. Goodness knows, we've all been there. We've all thought, gosh, this is completely unquantifiable. But regardless of how difficult it is and how speculative it is, you've got to assess it. Otherwise, assessing the loss of the tribunal is impossible. And the Dumfries and Galloway Council case I've referred to just because it makes the point that you can, so in that case, the tribunal have found that the claimant would find new equivalent employment so far as Sarah is concerned within 6 months of the remedies hearing, but his ongoing pension loss would continue until his normal pension retirement age because of the final salary pension benefit. So just be aware that you can take a different approach on that. I've referred you to the 2017 guidance, which has very recently been revised to take into account all sorts of recent matters, including the updating of the more recent Ogden tables and indeed the potential impact of furlough and the CJRS and matters of that nature. That the guidance looks terrifying because it runs to, I think, to about 180, 190 pages. But having spent years sort of dealing with the previous handbook, which again was very helpful, but did rather assume that the reader had quite a lot of knowledge about pensions, which frankly, certainly early in my practice, I definitely didn't. I think the new edition, because it's so detailed, actually is extremely helpful. So it's worth, if you've got a question about pension loss, that's your first port of call. And of course, it takes two different approaches, the contributions method for simple cases and the 7 steps model for complex cases. Again, for reasons of time, I'm not going to go through that in any great detail. I've set it out broadly there, but if you're interested, go to the guidance and have a look at it. But I just wanted to mention that probably the most important thing that is often overlooked is the adjustment factors when it comes to pension loss. And I've referred to the Janaki number 3 case, because that's the case that coined the phrase old job facts and new job facts. So this is the old job facts being things like looking at personal factors such as the health of the claimant, their family situation, where they live, economic factors like the introduction of new technology in their field, and the possibility of redundancies, and whether the claimant, for example, might have taken early retirement, whether they'd have considered a second career, and whether their earnings would have remained stable. So the point really to make is, for a respondent, that's going to involve a bit of digging. It's not necessarily something your clients are going to be alive to. It's worth looking at their career history as to whether there's any argument that they would have left that employment in any event. And similarly with the new job facts, and assessment of what the new job is going to look like. And adjustment factors can make a huge impact on the value of a pension loss claim. And of course, it's worth saying, in particularly complex claims, it may well be worth employing an expert and getting an actuary to calculate your losses, and ditching the guidance and leaving it to the experts. But of course, that's an expensive business. So familiarising yourself with the guidance is undoubtedly a good idea. So that draws to an end my section. I'm going to hand over to Ben. I'm going to stop sharing my screen so that Ben can hopefully share his, and then we can deal with any questions at the end.
Okay, thank you, Jude. Right, there we are. Share. Right, I think, yeah, okay. Is my screen loaded?
It is.
Right. Okay. Right. Thank you. So yeah, non-financial loss I'm supposed to be dealing with. This covers quite a number of heads, notably injury to feeling, injury to health, aggravated damages, punitive, or exemplary damages, but also interest and matters of that sort, but I'm not sure we've got time to cover all of that. So jumping right in with injury to feeling, we all know that this is very much recoverable in discrimination cases, but also detriment cases. And when we're talking about maximizing and minimizing awards, we know, of course, the Venter guideline sets out the bracket on the 3 bands for recovery or for injury to feelings. So for the most part, in terms of non-financial loss, you're going to get the maximum or not for a claimant, for a respondent defend a high value claim or not when we look at injury to health cases. The point to make for, I suppose, in respect of injury to feeling, more to those representing claimants, is that the burden is on the claimant to show that their feelings have been injured and to what extent. I think that's the key point, as I say, for claimants and claimants advisors, because when we look at the factors that a tribunal will take into account when assessing the appropriate level and amount for injury to feeling, you'll see that there are factors which the claimant, it's for the claimant to, as it were, in the shuttle of loss or in the statement, to focus on those factors, in my view, such as the vulnerability of the individual. Now, of course, it's for the claimant to set out if they are vulnerable, not just because of the discrimination, but it could be something to do with their health condition, which is one of the factors. But of course, this is an award made on the tort principles, so the eggshell principles apply. So that's to say that if the claimant reacted to discrimination more severely, for instance, than others, then they should be accounted for regardless of whether the discrimination could be viewed objectively as less serious. So it's a point for claimants to set out their particular position. This is not a situation to be shy or be a wallflower. If there are circumstances in your personal life which in effect led you to be more vulnerable to be hurt, or your feelings to be hurt by the nature of the discrimination, then this is where you set it out, and you have to set out those facts because it may influence, and very likely will influence, whether the tribunal awards you the amount you're seeking. So it's an evidential point for the claimant. Similarly, if the claimant is suffering from any medical conditions which may affect they're suffering, why they've reacted quite in the same way. The impact of the treatment on the victim, severity of the act of discrimination. Again, it's subjective. It's not an exact science. It's for the claimant to set out for the tribunal how they say under these heads without necessarily tabulating them in this way. But tell a story. It's invariably much more convincing if the claimant is able to tell the story about how the discrimination has affected them with these subheadings in mind. It's also the case that it will be relevant whether this is a one-off incident or a course of conduct. That's not to say that if it's a one-off incident, it will be a low award in the lower band, because indeed a one-off incident can merit an award in the middle band. I think there is a case which sets that out. I think it's called Bayes Children's Were Limited. So it will not be the case that it's a one-off incident, therefore we're looking at a low value award under the lower band. Of course, as I said, we know of the Vento guidelines, which is reviewed each year in line with inflation. That may suggest that that there is, as it were, a minimum award for the current year, 900. We all know about the maximum, which could be exceeded in serious cases. But it's worth bearing in mind that there is not by law a minimum. This is just a guideline. Having said that, it will be an exceptional case in which a tribunal either awards nothing in respect of injury to feeling, having found there to be a discriminatory treatment, or makes an award below 900, or depending on the year in question, below the minimum set out by the guidelines. But it is in principle possible. So Jude helpfully talked about the relevance and significance of schedules of loss and counter schedules of loss. I endorse those points. They are important, and it does require some thought being applied to them for the claimant at the beginning. Obviously, solicitors are used to, in advising claimants, not just looking at the question of whether they have a case and whether it has merit. They do also look at the cost benefit analysis, which would, in a discrimination case, include an assessment of the likely award to be recovered if the claimant was to be successful. But typically for us as barristers, certainly when we get cases, we jump right into liability, looking at whether you can establish liability if you're acting for the claimant. And matters of loss tends to come when you've received your judgment on liability for the most part. But for advisors, claimant and respondent advices, starting with claimant advices, the schedule of loss should really present you with an opportunity to begin to either gather the evidence you're going to require when you're considering injury to feeling or in due course injury to health. Once you've got the schedule of loss, for the respondents, a counter schedule is important. Hopefully a well-drafted schedule of loss sets out the basis for the claim being made. And it will be an opportunity for the respondent to begin to, as it were, marshal evidence in counter of those arguments. So we're looking at injury to feelings. That of course means that we have a liability judgment. There is a liability judgment against the respondent. In that regard, the judgment, in my view, begins to offer the respondent the best possible way of mitigating the potential award. And often overlooked is the point of an apology. Of course, most respondents will either take issue with the judgment, possibly an appeal. The witnesses may object to the findings made against them. But of course, an apology is not an admission. An apology is merely a regretful acknowledgement of an offense or a failure. So an apology in this regard could simply be limited to the findings made by the tribunal. It's not an apology, so it could be, it seems to me, worth getting that across to the respondents. And of course, it's of value as set out in Armitage, that it is indeed one of the greatest mitigation that a respondent could put forward. But as I say, it's often overlooked, or for other reasons, such as it implying an admission. But in my view, an acknowledgement, if not an apology, could be made, which is focused very much on the findings of fact made by the tribunal. Other ways in which a respondent can mitigate their liability in terms of remedy for injury to feeling are what I describe as practical steps, helps such as a counseling, for instance, offering counseling. As you said, the likelihood is that the claimant will reject these offers, such as meeting the cost of a recruitment where there's been a dismissal. But what it does do, the purpose is that it does hopefully convey to the tribunal that one, the respondent have acknowledged the findings made by the tribunal. The respondents are perhaps not that big bad employer, as it were. And no doubt, when it comes to the sense in which the tribunal views the discriminatory treatment, it's likely to be mitigated because they can see that the respondents are taking their findings seriously. Conversely, it can be the case that if the respondent does not take such steps, the evidence that they have failed to take such steps may be something which works against them. Certainly, a claimant can, if you're acting for a claimant, you can certainly point to those factors as something which adds to the injury to feeling that the claimant is suffered about the way they've been treated. And worse still, for the respondents, if the claimant is able to, as it were, extract evidence that the perpetrators have perhaps been promoted in the interim, and that's likely to support a higher injury to feeling award. Now, turning to injury to health then. This is the most common form of personal injury and discrimination claims, and in terms of psychiatric damage. So there are, of course, other forms of injury to health, but in discrimination claims, you would find that it is mainly a psychiatric damage that is claimed. And the point first we're making is that in terms of quantification, the Judicial Services Board guidelines is a good start for awards for general damage for pain, suffering, and loss of amenities. Having said that, it's important that the claim for injury to health is pleaded. It's not unknown for claimants in the tribunal, when they've succeeded on liability, for the schedule of loss to point to injury to health, or in fact, even before they succeed, the schedule of loss points to injury to health when one has been pleaded. So there is a need for this to be pleaded. And in that regard, if you have medical evidence, then the nature of that medical evidence needs to be set out in the pleading. The second point, of course, is to obtain expert evidence at an early stage in the process to support the contention that you suffered, or the claimant has suffered the injury, and that it was caused by the alleged treatment. Because although it's not a civil court, the tribunal still needs to have regard to issue of causation. It's important in this area to pick your expert wisely. It's not enough to have a expert report from somebody who, in fact, didn't have the, in terms of qualification, the discipline to deal with a particular medical condition relied upon. Other times it would be a GP note. Now, it's worth pointing out that medical evidence is not essential, but if we're talking about high value a claim against the respondent, you will, in my view, need expert report. In one case, which I might refer to a few times in the course of my session, the case of RBS and AB, the medical expert for the claimant, in the end, submitted 7 reports. I think that's probably at the top end, but this is the case in which the tribunal ultimately awarded the claimant 4.7 million pounds. So medical evidence is ever so important. Now, just another point about medical evidence. Sometimes in these discrimination cases, you will have multiple complaints of discrimination. The tribunal is issued judgment and perhaps only found on one head or 2 out of 10. And you've got a claim which involves injury to health. It's important to make that causal link between the injury to health and the discrimination found by the tribunal. It's also important to establish that the treatment being relied upon by the claimant is not one which is just in the background, or as it says on the slide, one that the tribunal has not in fact found for the claimant. That's really an apportionment point which one can dwell on. Now, another point which comes under this is the, so it's important for the respondents to be vigilant, I say, in such cases, to make sure that there is that correlation between findings made by the tribunal and the claims being made by the claimant in terms of damages suffered as a result of the discriminatory treatment. Turning to aggravated damages, of course, this is recoverable. As aggravated damages, perhaps not as often as you might imagine or expect, but the elements of aggravated damages we'll look at do feature and can feature in the recovery for injury to feeling award. So for instance, the factors, as it says there, this is generally recoverable, where the respondents have been shown to have acted in a high-handed manner, malicious, insulting, and oppressive manner in committing the act of discrimination. But it could also include the way in which they've conducted the hearing, or even, as it says here, an attempt to cover up or trivialize the wrongdoing. There are other ways in which this can arise, such as I said before, promoting or otherwise rewarding the perpetrator, using the claimant as a scapegoat, for instance, and as I said, the manner of defending the proceedings, including intimidating the claimant during litigation, for example, unjustified assertions that the claimant does not have a genuine belief in the subject matter of the claim, a continuing failure to correct a problem which has led to the discrimination, and where, for instance, as in Armitage, where the employer has failed to investigate complaints of race discrimination and failed to apologize. There are other factors and cases on this point. So for a claimant, you will be looking for evidence as part of your case for any of these factors. And where you have them, that will support your contention for aggravated damages. And for the respondent, you'll be looking again for existence of any of these factors. And where any exists, you should begin to look for evidence to counter or mitigate likely award for aggravated damages. So as I say, for a respondent, the sort of stuff you could do to mitigate the prospect of aggravated damages is ensuring that there are learning point sessions. You've got the judgment from the tribunal has made its findings, its criticisms of your handling, for instance, of the perhaps a grievance or disciplinary. There should be, it stands to reason, a sort of a learning point session with those involved. This could be done internally, or depending on the nature of the case, we're talking high value, it may be practical to bring someone external. And the idea is that you're able to evidence this come remedy hearing to show that you're taking steps to avoid a repeat of this kind of conduct. Those involved, there ought to be evidence of counseling. I suppose that's something as against evidence that they've been promoted or not even been spoken to. This is not uncommon in tribunals where respondents might take a very high-handed approach, as you might expect in high court cases, with a view to quote unquote intimidate a claimant. Now, I think it would be advisable to avoid the temptation of adopting such an approach in a discrimination case in the tribunal. Exemplary damages are recoverable, but thankfully they are very rare for the reasons set out there, which essentially, as I say, they are thankfully rare, because you would have to, for a claimant, you'd have to be demonstrating that the compensation recoverable on the injury to feeling, injury to health, if it's an injury to health case, and aggravated damages perhaps, is not enough to compensate the claimant for the wrong committed. It also has to be, as I say, oppressive, arbitrary, unconstitutional action by agents of the government, or where the respondent's conduct has been calculated by him to make profit, which may well exceed the compensation payable to the claimant. So very few cases will fall into that bracket. There's a case of Kudus and Chief Constable of Leicestershire Constabulary, Minister of Defence, and Fletcher, which says that exemplary damages are reserved for the very worst cases of oppressive use of power by public authorities. Contributory fault and negligence. It occurred to me that a respondent might wish to argue in cases, as we often find, unfair dismissal case brought along with a discrimination case. What happens if the tribunal finds unfair dismissal but also finds contributory conduct? And what if the dismissal is discriminatory? Can the tribunal, as it were, reduce the award for unfair dismissal and the discrimination? In principle, it can be done, but rarely ever. The point was considered and clarified in the case of First Great Western and Iago in 2018. Essentially, it seems to be a policy argument that it can't be seen, or it shouldn't be seen, that the claimant in that situation is being blamed for discriminatory conduct. The idea of blameworthy conduct doesn't sit well with a finding of unlawful discrimination. So any arguments of mitigating award in this regard better confined to issues of causation and mitigation in the usual way. So we've got the situation of individual respondents, which is quite common, where for a claimant, you might want to do that for tactical reasons, as I say, either because you want to bring the respondents to the table, but in most cases, claimants do it from a position of actually misconception of what they need for evidential reasons. They think they need the manager concerned, the directors named as respondents in order to be able to bring the evidence before the tribunal. So it seems to me that for a claimant, tactically, you'd want to do that as a way to bring pressure on the respondents to come to the table, where you know that they might be nervous about having the named individuals as well as the employer. Of course, the practical answer to that is that in those cases, the respondents can, off the bat, as it were, take a decision to meet liability against the employer and the individual respondents, if indeed the tribunal found as such. That takes away that tactical advantage. And of course, if the claimant continues to insist on the individual, pursuing the individual respondents, that might be something which could be weighed under an application for cost in due course as unreasonable conduct. So I'm conscious of time. So jump into settlement. As Jude said earlier, the real high value claims often settle. We know that. And again, the value of a good shuttle of loss and a counter shuttle of loss can be overstated in respect of settlement. It's certainly for the claimant, if you do that and do that successfully, it certainly puts the respondents on notice that they've got a case on their hands. And for the respondents, the value of a good counter shuttle, of course, begins to put the claimant, again, on notice that the case is either unrealistic, overinflated, and gives you an opportunity to put pressure, cost pressure on them. But as I say, every now and again, a case comes along that doesn't make sense on many levels. In this context, I think the case of RBS against AB is just one of those cases. And just very briefly about that case, on shuttle of loss and counter shuttle of loss, following a liability judgment, this is a multi-day case. AB had suffered an accident on the first day at work, a road accident, smashed her leg, and although she carried on working for RBS for another 4 years in Stratford, I think she wanted a transfer closer home. For those 4 years, she was either on crutches or on a brace. So the employer knew of her disability, but her requests were often refused. Highly litigated case, tribunal issues judgment on liability in favor of the claimant. It's evident from the judgment that the respondents had a case strategy, which was that the claimant was exaggerating her symptoms. Of course, once you get the judgment on liability, you know whether you have succeeded with that case strategy. And that calls for a change or an alteration in your case strategy. That didn't appear to be the case here. And you had a schedule of loss, which was for 10.5 million, and a counter schedule, which was for 75,000 pounds. The disparity is mind-blowing. The tribunal then gave a first judgment on remedy, which sets out the parameters on the various elements, and then sent the parties away to agree on a figure. Unfortunately, they couldn't reach an agreement. In the end, the tribunal had to make a judgment and awarded 4.7 million. Most of that was for future personal care, because AB, based on the medical report, had been, as it were, identified as somebody who would need that care for her own safety going forward. So settlement is important, but there are cases which suddenly, with the best will in the world, escape that as a way of avoiding a high value claim. I imagine those advising RBS will look back and at all the missed opportunities when they could have settled that case for perhaps £1 million, and it would have been a great result. Lastly, mediation. Mediation is, of course, a very useful tool in settling complex discrimination cases. It's more for respondents, I think, to identify this at the early of and offer it and really pursue it with vigor to get mediation and hopefully avoid the trauma of a hearing, that trauma being for both sides, not just for the claimant. And it's also the fact that mediation offers both sides an opportunity to get that which they can remedy that they cannot get from the tribunal. You know, things like retraining, mentoring, and matters of that sort. Transfers, and you name it. So the claimant can actually put forward remedies which they could never get from the tribunal in mediation. And it seems to me, not just speaking as a mediator, but I think it makes sense, especially where there is still subsisting employment relationship, even after liability. So conscious of the time, we've overrun slightly, and there are a few questions. I haven't looked at them, but Jude has. So I'll pause here and let you take the first cases, and I'll have a look and see what I can take. Thank you all.
Thanks, Ben. Yes, I mean, I'm conscious that we're just after 6 o'clock. This is a huge topic to be able to deal with in an hour, but there are a few questions. So for those of you that are able to hang around for a few minutes, Ben and I will try and answer those. So the first question is, if a consultancy agreement is terminated and the consultant turns down the opportunity to submit a tender due to alleged race discrimination, could the respondent use this to argue that the consultant failed to mitigate losses if the consultant is in fact an employee? So it seems to me that this is analogous to the sort of offer of re-employment type cases where, following a dismissal, an employer seeks to often tactically make an offer of re-employment. And the case that comes to mind is the Wilding and BT case, which was a disability discrimination case where BT made an offer of re-employment to Mr. Wilding after the tribunal had found that he'd been discriminated against, but at the same time as appealing the decision. And Mr. Wilding turned down the employment, I think from memory, not least because he said it was slightly inconsistent with appealing the decision that he'd been discriminated against. But there we are, he turned it down. And in fact, the tribunal concluded that that was a failure to mitigate. So it certainly is an argument that you can make. I'd caveat that quite heavily, though, with the fact that the difficulty with those sorts of cases is often you'll get the response from the claimant, well, hang on a minute, why should I come back and work for you when you've just been found to have discriminated against me? So that's the challenge with making an argument, but it's certainly not an impossibility, and there are cases out there where it's succeeded as an argument, but it very much is dependent on its facts, I think.
Right. I'm going to jump, Jude, and take slides. Yes, I think the slides can be shared. I think there's one which is very much focused on, or two focused on the bit that I covered. Kind of respondent asked the claimant for disclosure of their Fitbit records, including sleep and activity, to dispute their claim about impact of discrimination on their health. Well, that rather presupposes that the person has a Fitbit. I don't know that it's now everyone has it. I certainly don't have one. But if it's part of something provided for work, I don't know, perhaps you can ask for it. If I was for a claimant, I mean, it can, I suppose, that be as part of the medical record. Yes, you can ask for the medical record. But even if you got their Fitbit and it does show that they do take exercise, I don't see that means that, again, it depends on the nature of the injury that they claim they suffered. So I don't know whether Jude has something.
Yeah, I sense it's unlikely to be well received. I can see why it might be tempting to do it where you've got specific evidence from the claimant where, for example, the claimant is saying, you know, my mental health was so badly affected that I couldn't sleep, for example, and you might think there might be evidence that showed they can sleep. And I'm always a bit dubious about how accurate these Fitbits are about monitoring your sleep in any event. So I can see why, in a very specific situation, that might occur to you. It's very personal information, so query just how relevant it is and whether a tribunal would be prepared to order it. Also, it might backfire on you because a Fitbit might say that they've got a terrible sleep record, and that then you don't quite know what it's going to say. So it's a bit like the cross-examination. Don't ask a question you don't know the answer to. So I'd be careful. But it's certainly a novel idea. I've never come across it in any of my cases. It reminds me of when we first started doing CVP hearings, and I lost my internet connection just before my first trial, and my Fitbit told me to relax and breathe. So they do have a scarily accurate monitor on what happens. But yeah, I'd be cautious. You don't want to be seen to be being very aggressive. It's slightly treading on the territory of private investigators monitoring people, which tribunals always frown upon.
And I think just the last point on that, the best way is a medical examination. If you are really concerned about that, see if they'll subject themselves to an expert examination. And again, Jude's point, you may get answers that you don't want. So there you are. Somebody is taking issue as to whether injury to health is recoverable in employment tribunal. Isn't it personal injury, they say? Why would it be necessary to plead it? Well, I think that means the point. It is, the short answer is that it is recoverable. So it does need to be pleaded.
Yeah, and there's a question about whether offering to assist a former employee with their job search, whether does that not imply some level of admission of liability? I would say no. I mean, again, it depends on the facts of the case, and it depends the point at which you are doing it. But in the context of where you've already got litigation and you're looking at future career loss, it's unlikely a tribunal is going to criticise a respondent for that and think it amounts to an admission of liability. And often these things do happen once you've got a liability decision and you're dealing with remedy. So that ship has rather sailed at that point in time. But again, it depends on the facts, but I wouldn't be particularly concerned about it, not least because I suppose it might depend on the reason why the individual was dismissed in the first place, but of course it's very common nowadays for employers to offer those kinds of services as part of an exit package or just ordinarily following a dismissal. So I wouldn't say it suggests anything sinister.
Right. And lastly, I think Dean Morris was the best source for info for guidance on levels of injury to feelings. I believe that is a word. Yeah. I think I said it's not an exact science, and each case very much on its own facts. But I do find when I have to deal with this practical law, and I think IDS provides from time to time commentary on awards which have been made. I don't know, Jude, what you expect.
Yes, and the equality law reports and sources along those lines is the best. But as Ben says, every case so very much turns on its own facts. But so, I mean, really your best way of doing it is to look at previously decided cases and try and draw some analogies there of the levels of award. So that's really your go-to. Somebody also asked, do you gross up schedules of loss for tax? The difficult question. I mean, yes and no, because the difficulty is grossing up is, of course, the very last thing that has to happen. So I think it is best practice to gross up figures in a schedule of loss in the sense that you're saying this is the actual award that needs to be made. But of course, the reality is the grossing up always has to be done again because the figure that's actually awarded is never actually the amount that was on the schedule of loss. So it's kind of a mathematical calculation that's wasted, but it nevertheless gives you a sense of it. So for example, and it is important to look at grossing up because, for example, I mentioned at the beginning the award recently that Croydon made, where the global award was 2.5 million. I think about 1.1 million of that was grossing up. So when you're looking, for either party, don't overlook that because you might be advising your clients that an award is significantly lower than actually it's going to end up to be. So for your own purposes, really, yes. But yes, the reality is that the tribunal is probably going to have to ask you to do some grossing up on the hoof once the actual award has been made in any event.
Great. That brings us to an end, and good to see that we've still got people here. If you have left, not given the time, and thank you for those who remain, and thank you for attending. I believe this will, I think it's been recorded and may be uploaded at some point, and I'm happy to share my slides. I think Jude say.
Yes, absolutely. Somebody asked whether the slides can be circulated after the talk. Absolutely, they can, and hopefully we will publish the recording. So that information is there.
Once it's been edited, so I can powder my forehead.
Of course, yeah. Of course.
Okay.
So thank you everyone for attending, and we'll bid you a good evening.
Good evening.
Bye.